Good morning, everyone. We're here today for oral arguments. We're going to begin with Appeal 23-1648, Continental Indemnity Company versus BII Inc. et al. Mr. Ansbach, we'll begin with you.
Good morning, Your Honors. My name is Kenneth Ansbach. I represent the judgment creditor, Continental Indemnity Company. Your Honors, the district court had jurisdiction over the garnishment proceeding that was brought by Continental Indemnity to enforce its judgment obtained against the judgment debtor BII Inc. on July 7, 2021.
Mr. Ansbach, let me just start out by asking you to explain to us why we are having this debate at all, since Judge Pallmeyer invited you simply to file a new complaint against Starr downstairs for, I think, a lower filing fee than filing for an appeal.
I'm here, Your Honor, because the proceeding that we filed, the garnishment proceeding, is consistent with Seventh Circuit law on the subject.
I understand you think you're right. I'm
Yeah.
trying to understand the practical consequences of deciding this case either way. It looks like the difference between a circuit filing fee and a district filing fee, unless there's something I've overlooked.
Well, we're not obligated to go back to square one and refile.
Maybe, maybe not.
Yeah.
The question is, why does it matter to you? I understand it's the principle of the thing in your mind. You think you were right. We'll talk about that. But before we get into all the doctrinal nuances of ancillary and supplemental jurisdiction, I'd like to understand why it's important.
So you'd like to understand why we feel it's important to
do this under the 5520 docket number rather than a new docket number.
I think you already said why it's important. We feel it's important, that's all. We feel that we are right, that we were justified in bringing the garnishment action, that Judge Pallmeyer was wrong in dismissing it, and we should be able to proceed with that proceeding.
Okay.
You may continue.
Okay. All right.
It's, go ahead.
Go ahead. Okay.
No, it sounds like we're here over about $100. Is that right?
I don't think so. I disagree. Your
Okay,
Honor.
what's the difference?
The difference is the principle of law.
Okay, let's talk about principles of law. There are some kinds of federal jurisdiction that are mandatory, right?
There are I'm sorry, I didn't hear what you
There are
just
some kinds of federal jurisdiction that are mandatory.
Yes,
The district judge must exercise jurisdiction, right?
correct.
Supplemental jurisdiction and ancillary jurisdiction have a long, they're two words for the same thing pretty much, but they have a long tradition of being discretionary. You may be right that the district judge could have exercised jurisdiction. What rule or precedent required her to exercise her jurisdiction to hear your complaint against Starr as part of this, part of the ancillary jurisdiction of your earlier case against BII?
The Peacock decision of the United States Supreme Court.
Says you must?
It says the courts have jurisdiction.
That's a different question. I'm not asking about the maximum scope of ancillary or supplemental jurisdiction. I'm asking about what makes this mandatory. Even Argento, your best case, talks about this as a discretionary matter.
Your Honor, perhaps you're right. Perhaps it is discretionary. But all the precedent, both in the Seventh Circuit and in the United States Supreme Court, including Kekkonen, would point in the direction of exercising that jurisdiction over this case. Why should Continental Indemnity be singled out as not being able to exercise their rights under the law?
Well, that assumes the conclusion. Is it a right, or is it an opportunity to ask the district court to exercise its jurisdiction, like asking for a declaratory judgment?
Well, even that, in that instance, asking for a declaratory judgment, I don't think gives the district court the right to just dismiss the declaratory judgment action because they don't feel like exercising jurisdiction.
Well, because you don't feel like it is a straw man, but because there may be debatable questions about jurisdiction, might be a good reason to say, why don't you start in a new action where jurisdiction would be unquestionable?
Well,
Because you absolutely, as a district judge, have discretion in these matters.
was that a question?
It's a comment.
Okay.
And further invitation for you to explain to us why the district judge was required, or why it was an abuse of discretion not to exercise that jurisdiction in your case.
Well, okay, so that's a different issue. If you're saying it's discretionary, and why was this an abuse of discretion?
That's the pivotal issue here, yes.
Okay, all right. And I say it was an abuse of discretion because all the precedent, you mentioned Argento, I mentioned Peacock, a number of other cases cited in my brief, including Green, which is directly on point, would, I think, require this court to say it was an abuse of discretion to dismiss the garnishment proceeding. Particularly Green, Judge Pallmeyer said that a garnishment proceeding which is brought to determine coverage under an insurance policy necessarily introduces so many new issues that it is functionally a separate case under the Yang decision.
Mm-hmm. Certainly it could be removed separately from a state court, right?
Yes.
Okay.
Yes. And the Green case was just such a garnishment proceeding brought against an insurance company to determine rights under an insurance contract.
Did anybody question the exercise of supplemental jurisdiction there?
No.
I
However,
didn't think so. Okay.
Excuse me, Your Honor, this court quoted the identical language from Yang that Judge Pallmeyer quoted as the basis for her declining to exercise jurisdiction, the language that I just repeated. And this court quoted that language and then proceeded to affirm the district court's exercise of its ancillary jurisdiction over that garnishment proceeding to decide that there wasn't coverage under the policy.
No material facts from the underlying proceeding overlap the insurance contract dispute. Given that gap, isn't it within Judge Pallmeyer's discretion to do what she did?
I don't see how the one thing has anything to do with the other. Just because there were no facts from the underlying proceeding that overlap this garnishment proceeding doesn't mean that Judge Pallmeyer was justified in dismissing it. In almost every garnishment proceeding against an insurance company, there wouldn't be any underlying facts that overlap.
Well, there's something that tethers the two actions. The debt itself is attempted to be attached to an asset. Here, the tethering is 2 or 3 steps down the line, hence her decision. And obviously, this is, given the discretionary nature of the decision, we're trying to determine, was she beyond the pale by making that? And we need, we're looking to you for what reason you're offering as to why it was an abuse of her discretion.
Well, it was, number one, an abuse of discretion because Judge Lee already found there was jurisdiction in this case. When
You're relying on the conditional judgment,
I am.
which was ex parte, no appearance from the other side, no addressing of the jurisdictional questions.
That is absolutely correct, Your Honor. I am relying on that because this court has said that a default judgment reaches the merits and that one cannot reach the merits without exercising jurisdiction.
Mr. Ansbach, can I ask you a question? I want to go back to Judge Hamilton's questions at the beginning because I want to make sure that I totally understand this. I'm not asking you a question about strategy, but there's no statute of. I mean, here's the way I view it. Okay, if you were to go downstairs right from here and file a diversity jurisdiction action, there would be no question that the district court would have diversity jurisdiction. You'd file your complaint. I assume the defendant would file an answer almost immediately and move for summary judgment right away because their position on the merits is that they don't owe CNI anything and they would want a decision on the merits quickly, which is also what you want. Judge Pallmeyer may decide the summary judgment motion before we issue an opinion in this case, which would send it back to the district court to begin district court proceedings. And I just want to make sure that is there a statute of limitations problem? And if you don't want to tell me that maybe there's a strategy problem that you don't want to tell me about, you can just tell me I don't want to tell you. But is there a legal impediment to you filing an action in the district court under which clearly the district court would have diversity jurisdiction? If it's strategy, you don't have to tell me. Okay, I'm not aware of that.
I'm not aware of a limitations issue that would apply. On the other hand, I would say this, summary judgment motions were already pending before Judge
I know,
Pallmeyer.
so they just package them and refile them. That's what I'm saying. You've asked interrogatories, you've taken discovery. It seems to me like there's really nothing to do in the district court except a complaint and an answer. That would be new.
Well, I disagree with that because the discovery that was done in the case below involving Starr was simply Starr's answers to garnishment interrogatories, which contained admissions, which contained judicial admissions, which would not apply in a refiled diversity jurisdiction case.
Why not?
Well, I'm not sure about that.
Well, it's a different proceeding. A judicial admission would only apply in the first proceeding.
Well, if they changed their admissions, there'd be pretty strong impeachment, wouldn't there?
Probably,
Would you like to reserve the remainder of your time for rebuttal?
yes.
All right, thank you. Thank you, Mr. Ansbach. Ms. Dixon will now move to you for argument on behalf of the appellee.
Good morning, Your Honors, and may it please the Court. My name is Karen Dixon, and I represent Starr Indemnity and Liability Company, which is a garnishee appellee in this matter. Starr requests that this Court affirm the judgment of the District Court dismissing the garnishment proceeding against Starr for lack of subject matter jurisdiction and vacating, not a default judgment, it was a conditional judgment against Starr for 2 reasons. First, the District Court had the unquestionable ability to address subject matter jurisdiction at any time under Rule 12H3 and a wealth of precedent of this Court as well as the Supreme Court, as well as the ability under Illinois law to vacate a conditional judgment which had been entered against Starr because it had failed to appear because the garnishment citation was put in the mail to New York City during COVID, and they did not get it in sufficient time. Second, the District Court correctly determined that subject matter jurisdiction was lacking over Starr in the dispute over whether or not the STAR policy provided coverage for the underlying Lumpkins injury because it was a functionally new lawsuit with distinct and disputed issues outside the scope of this court's ancillary jurisdiction under Rule 69.
Do you
Why
think-
is
Go ahead.
why is there not diversity jurisdiction here?
If a complaint were filed by CNI against STAR, there would be diversity jurisdiction.
But why does there have to be a complaint? Where does Rule 69 say anything about not only ancillary jurisdiction? I just don't read it in the rule, and I think we have cases. There was a case called, let me see if I can, Kelly versus Stevanovich from 2022, where we write, to enforce the judgment, the trustee turned to Stevanovich, an Illinois resident, and filed a post-judgment supplemental proceeding in the Northern District of Illinois, which was under Rule 69. And then we go on, under the court's diversity jurisdiction.
But that cannot substitute for, within the context of ancillary jurisdiction. This court held in Travelers versus Good, it involved a similar proceeding in which there was a citation to discover assets in an underlying Illinois case. What happened in that case, similar, there was a tort action. They served a citation against the insurance company, and the insurance company removed the action to the federal district court and said it is a functionally new lawsuit. We have parties and issues that were not at issue in the tort action, and this is a functionally separate case. This court agreed that when a garnishment action brings in a new party and raises new and distinct disputed issues, the proceeding is not a substantially continuation of the suit, and therefore it falls outside the scope of Rule 69 and ancillary jurisdiction. Now, that court had found that subject matter, that diversity jurisdiction was lacking because the amount in controversy could not be met. And in fact, this court commented that the court need not bend over backwards to construct alternative theories to persuade itself that subject matter jurisdiction exists. So Judge Pallmeyer, when she was reassigned the case from Judge Lee, we had objected at the time after the Rule 69 does allow the discovery of assets, and we don't contest that. We responded to the citation. We provided answers saying the STAR policy simply does not apply here. In fact, STAR never received notice from its policyholder of any of the three preceding actions.
The reason I ask that question is it seems to me that STAR is in a position where it would like a quick ruling to end the litigation, because your position is very simple, that your policy at the time of the accident does not cover the injuries, period. I mean, so it seems to me that both parties would benefit from a ruling on the merits, and they're not going to get one here, no matter what happens. No matter what happens, it seems to me like this is going back to the district court, either under a new complaint or a remand in this case. I go back to Judge Hamilton, I'm just not sure what we're doing here.
I agree, Your Honor, and when we received the March 1st, 2023 ruling from Judge Pallmeyer.
But my question is a little different to you, because I guess legally, how do you benefit from forcing them to file a new complaint? If the district court has diversity jurisdiction, why can't the district court just exercise its diversity jurisdiction in the supplemental proceeding under Rule 39 and end it on the merits, which is kind of the reason for Rule 69?
Because this court has said Rule 69 as an ancillary proceeding, that exceeds the scope of what was at issue in the main action. I agree, we expected a complaint to be filed. Therefore, there's no question about subject matter jurisdiction. And in fact, Judge Pallmeyer invited my opponent to tag the case, make it related, but there has to be subject matter jurisdiction.
Are you saying she could not have exercised jurisdiction over this?
We believe that the Seventh Circuit has expressed that when there is a functionally new lawsuit with new parties and new and distinct legal issues, that falls outside the scope of ancillary
Do
jurisdiction.
you find that as a bright line rule in Travelers Against Good?
It is in Yang versus City of Chicago. Travelers versus Good went on, recognized that there are limitations with Rule 69, but recognized that the insurance coverage dispute that can arise, not in a tort case, is a functionally new suit
Well,
that falls outside.
it can be.
Yes,
It does not necessarily, I mean, there are plenty of Illinois cases that use proceedings to execute, garnishment proceedings to resolve coverage issues, right?
if there's no objection. And my opponent cited Green versus Westfield Insurance Company, a decision of the Seventh Circuit, but in that case, the insurance company was made a third-party defendant. So here,
Would you agree that at least the right category for approaching this is under 28 U.S.C. 1367, the scope of supplemental jurisdiction?
in Rule 69, yes.
Well, Rule 69 cannot expand jurisdiction, right?
Correct. And the issue here is that Rule 69, the execution is entitled execution. The point of a garnishment proceeding is supposed to be a attachment of the turnover, a bank account turnover, wages.
Though it's clear that that is the most common
Correct.
and the easiest way to use a garnishment proceeding, but there also are cases authorizing its use to resolve disputed coverage issues, right?
It can happen.
Right.
It has happened, but we object to it happening here. And we expected, as after the district court made its correct determination that it had an independent obligation and it could at any time under Rule 12H3 find and determine whether it had an independent obligation to assess subject matter jurisdiction. The district court correctly concluded that it did not and invited my opponent to file the lawsuit and tag it as related to this case. That is what we expected to happen, but it did not. We've been on this appeal for 11 months now. The citation proceeding started in August of 2021. For 2.5 years, we have been in a supplemental proceeding in an action that had nothing to do with the dispute over the STAR policy.
So your position is not that Judge Pallmeyer had to do what she did, but she had the discretion to do what she did?
Correct, and she had the obligation to question whether she had subject matter jurisdiction. And she did so, and she was correct in her determination that this exceeded under this court's instruction in Yang, as well as Wilson, Travelers versus Good, that when the dispute involves a new party and a completely unfactually connected dispute, that the proper procedure is to have a separate action in which there's no question that there is subject matter jurisdiction.
Well, the rubber meets the road. I mean, I got to say, the stakes here seem trivial as between these two parties.
Agreed.
But what we've got to do is make sure that we don't mess up the law for a party in your situation where diversity is not present, where you want to stay, where a party like you wants to stay in state court or be sued in state court, if at all. And that's whether that's a bright line mandatory rule or a discretionary rule is something that we need to think about.
And the problem here, Your Honor, is that in parlance, declaratory judgment insurance coverage actions are routinely litigated in state court, in federal court. They are separate and apart from the underlying tort suit. If there is lines we draw, this could allow litigants to simply invoke the coverage action in the underlying suit by way of third-party complaint, by way of supplemental proceedings, and have a lawsuit following a lawsuit that the district court simply do not need. And we ask that this court consider when it draws geographical boundaries, if we still have to get back to subject matter jurisdiction. And
Well,
here,
there's also the challenge, if you're a district judge, of trying to get a case settled if you can't get the insurance company in, right?
but Illinois is not a direct action state. So especially here where Star never received notice or a tender of the claim from its policyholder, because the policyholder in one of the three underlying proceedings, actually two of the three, had admitted it was uninsured at the time of Mr. Lumpkin's fall. That to allow a coverage action to just simply be a supplementary proceeding would exceed the ancillary jurisdiction of the court. So we ask that this court affirm the district court's determination of the lack of subject matter jurisdiction over the coverage dispute involving Star, and that the district court correctly determined she lacked subject matter jurisdiction, she did not need to exercise it, and she properly vacated the conditional judgment, which was not a default judgment, a conditional judgment. And
Ms. Dixon, let me ask you a variant on the proceedings here. Suppose that that BII had appeared and had simply pled a third-party claim for coverage against Star within the underlying district court case. Would there be a problem with that?
if BII, which was diverse from Star, it is possible.
It's diverse from CNI.
Correct, and if the district court exercised supplementary or discretionary jurisdiction over the third-party claim, that could have happened, but it typically does not happen within the tort action itself. A separate coverage action is filed.
But it could.
It could.
Yeah.
And in Green versus Westfield, Green was impleaded as a citation respondent, but a third-party complaint was eventually filed, making them an actual party to the lawsuit. And here, Star doesn't have a complaint against us. We don't know what the theory of recovery is but we understand they say the policy applies and we disagree. But are they going to allege breach of contract? Are they going to allege declaratory judgment? They're alleging there's a duty to defend, even though Star's policyholder never asked them to defend, sought coverage elsewhere, and was unsuccessful. And those are important to determining. It's not just, hey, here's an insurance policy. Does it apply? There have to be legal theories of recovery, and that is another reason why it's important to have a complaint identifying the parties as well as the causes of action, and not simply saying, does the policy apply or not? Because there are legions of insurance coverage decisions of what I've done for 27 years. They're separate lawsuits.
Thank you, Ms. Dixon.
Thank you.
Mr. Ansbach, we'll go back to you now for rebuttal.
Your Honor, esteemed counsel for Star several times in this oral argument and in her brief said that in Green, the insurance company was sued as a third-party defendant in the underlying action. That is simply a complete mischaracterization of the Green case. In Green, the insurance company was a garnishee defendant exactly in the same position as Star here. There was the words third party or third party defendant never once appear in that decision. They were not a third party defendant. The Westfield Insurance Company was a garnishee defendant, the same as Star is here. That's number one. Number two, why is it an abuse of discretion for Judge Pallmeyer to have dismissed our garnishment proceeding against Star? I did not find a single United States Supreme Court decision or a single Seventh Circuit decision which held that a garnishment proceeding to enforce a judgment in the district court against an insurance company was not the subject of ancillary jurisdiction. That ancillary jurisdiction could not be exercised in that situation.
What do you do with the Erickson case in Illinois, where you have the Illinois court saying that the garnishment proceeding could not be used? The court did not have jurisdiction to adjudicate the validity of the indemnity agreement between the parties in that case.
It was an indemnity agreement. It was not.
What else is an insurance policy?
Pardon?
What else is a liability insurance policy? Sometimes, anyway.
Okay. I don't remember the facts in Erickson.
Okay.
Your Honor. Yeah.
Okay, thank you.
Okay.
Thank you very much, Mr. Ansbach. Thank you very much, Ms. Dixon. The case will be taken under advisement.
Okay.
We're now going to move to Appeal 23-2672. This is Pillar Domer versus Menard, Inc., and we'll begin with argument from the appellant, Ms. Gold.
Good morning, Your Honor. May it please the court. Sophia Gold on behalf of the plaintiff, appellant, Ms. Domer, and the putative class. Maynard's, as the party seeking to compel arbitration, bears the burden of establishing assent to its contractual terms. Maynard's can't do that when it presented consumers like Ms. Domer with a cluttered checkout screen when the hyperlink to its terms of service was on the other side of the page from the large blue button that consumers were required to click.
What was cluttered about it? I got your point about it's on the other side of the page, but what was cluttered about it?
There's several points of information that's being presented
What should they have done? You know, I love reading these cases. Well, it was blue, it should have been green. It was on the left side of the screen, it should have been on the right side of the screen. And I think, doesn't this seem, like, your point, they talk about gift cards first, right? Well, should they have talked about it second? Would that have made all the difference here? If it was the second sentence instead of the first?
Absolutely, Your Honor. This court in Skoros versus TransUnion actually provided website owners like Maynard's with the roadmap. This court in Skoros said very clearly that the way to put consumers on notice is to place a hyperlink to the agreement next to an I accept button that unambiguously pertains to the hyperlinked agreement. So I would contend that there are two ways that Maynard's could have done that on this very screen. They could have included a checkbox. That's the obvious way. That's the easy way. Include a checkbox that says, I agree to the terms of service. But they didn't actually have to do that. What they also could have done is they could have included a much larger disclaimer right next to the submit order button that said, by continuing and clicking submit order, you're agreeing to these terms, blue hyperlink, here you go, here are the terms that you're agreeing to. Courts across the country have held that is sufficient when you are providing.
Yeah, they could have, but did they have to?
Well,
It's a weird thing to me because you've got this. You're arguing over $1.40 fee, right? That's what you're arguing over. I mean, I understand you want a class and you want 100 million people in the class arguing over the $1.40 fee, which is clear and obvious, right on the screen, right? And then you're saying the terms that they could have been a little bit clearer on the website, which, by the way, Menards has an extraordinarily simple website. You compare it to Amazon's, which is, boy, Amazon. It's hard to find what you're looking for at Amazon. Not for the Menard screen. I mean, it's almost so simple it looks like basic.
Well, Your Honor, I would have to respectfully disagree with you, and I would refer Your Honor to, for example, the Uber screen that the First Circuit looked at in Cullinane. There were hardly any words on the page of that app, and one of the terms was, by clicking continue, you're agreeing to the terms of service. And the First Circuit still had no trouble in finding that that did not constitute reasonable notice, that those terms of service were not clear and conspicuous because they were not in all caps, they were not larger than the rest of the text on the page. It was easy to overlook them. And this,
Ms. Gold, I didn't see any indication in this record that you all had asked for a jury trial on the issue of arbitrability, which the FAA allows.
that's correct. We have not asked for that, Your Honor.
Why? I don't know about my colleagues, but I've presumably all read not quite as many of these cases as you and your opposing counsel have, but I find myself saying, why on earth should I be deciding this? Why isn't this a jury issue suitable for expert testimony from experts on web user interface design?
I will tell you that as a practical matter, if every dispute about arbitration were to go to trial, the courts would be flooded with these sorts of trials. I will say
it would only take a few. I would expect.
courts have said that if you can decide the issue as a matter of law, and here the facts are undisputed, the court is free to do that. Of course, as the Second Circuit pointed out in Nicosia versus Amazon, when they remanded and said it is not clear that that reasonable minds could differ as to whether assent could occur here. That would be another option for this court, is to remand and determine that reasonable minds could differ and send it back. Absolutely, Your Honor. I think that would probably be a bench trial, given that neither party has requested a jury trial, but absolutely we could go to trial on this issue. The problem is that the court decided it as a matter of law on the lower level.
Well, you did not ask for a hearing, did you?
The court decided without a hearing.
You did not ask for an evidentiary hearing, did you?
We did not ask for an evidentiary hearing. That's correct.
The Nicosia case is tough for you, though, because when you look at the Amazon screen versus this screen, the Amazon screen is just so much more complicated.
I disagree, Your Honor. I actually think that the Nicosia case is very similar to what's going on here, in part because in that case, the very top of that page said review your order, and then it was right under review your order where it said, by placing your order, you agree to our terms of service. And if you put yourself into the mind of a consumer who's going quickly through these screens trying to check out, the couple of places where their eyes might go might be the very top of a page, because we read left to right, because we look at headings to see what the page is about, and then the buttons where your eyes are directed to go, where the website designer has specifically directed consumers to go. And in this particular page, we don't have the terms of order at the top of the page right underneath the heading. We have it at the very, very bottom, and instead we have this large button over here that says submit order. It's the only thing in blue that's on the page. It's very clear that the eye is directed to go to the submit order button, and you can miss this disclaimer entirely. It's very easy to miss this disclaimer. And even if one were to see this disclaimer, when you read it, you go to see that it's about gift cards. And as every child is taught in grade school, topic sentences are important. They focus the reader as to what the paragraph is about.
Should they have had another paragraph? Because then I think you'd be arguing they had two. They should have had one. Right? I mean, should they have had another, like, please note, please note, please note, please note, with every little thing separated, so you had to read 4 please notes?
I will be clear. I do not think that even if this gift cards, those first 2 sentences were eliminated, even if it just said, please note by submitting your order, you accept our terms of order, and it was in this size font, and with this coloring, without in all caps, without a underline, without any sort of emphasis that this is a hyperlink that you need to read and that this is very important, I still believe that this would not be enforceable. However, because those first two sentences are in there, I think it's a much easier case.
I just wonder in 2024 if anybody ever buys anything on the internet, ever, not realizing that they're agreeing to some terms of order at this point in the world that we live in.
Well, it was just in 2016, that wasn't that long ago, when this court in Skoros said a person using the internet may not realize that she is agreeing to a contract at all. And it was just last year that the Ninth Circuit in Berman versus Freedom Financial Network said, because of the nature of online contracting, the onus must be on website owners to put users on notice of the terms to which they wish to bind consumers. This is the framework that courts across the country have established as to what's reasonable. Maynard's very easily could have designed its page to follow that framework, and they didn't.
Would you like to reserve the remainder of your time?
Yes, thank you, Your Honor. Thank
Thank you, Ms. Gold. Mr. Titici, we'll move now to you.
Good morning, Your Honors. May it please the Court. Mark Titici on behalf of the FLE Menard, Inc. Your Honors, I want to start, I guess, with Judge Hamilton's question about, is this a question of fact, question of law? I agree with Ms. Gold. Courts say when the facts are undisputed, as they are here, it's a question of law that can be decided by the court. The Ninth Circuit actually has a case that really walked through that question in detail. It's an Oberstein case. It's 60 F. 4th. 505, I think it was actually Judge Boggs from the Sixth Circuit sitting by designation, but it really walks through that analysis in detail. And again, as Your Honor noted, Ms. Gold didn't request a hearing here, so I think we're pretty clearly in territory where this is a question of law that Judge Peterson correctly decided in the first instance, and this court is reviewing without regard to a factual question. Second, on Nicosia, Your Honor, the procedural posture there was a little bit different, again, related to the factual question. The Second Circuit had an unusual procedural posture. It was considering the case on a motion to dismiss, not the motion for summary judgment-like style here. So basically it concluded if you could plausibly state that you didn't have notice, it remanded for what you do when you deny a motion to dismiss. You move into discovery, and that's what happened in that case. So again, a different context than here. I guess Ms. Gold spends a lot of time, both in the brief and here, talking about the location of the disclosure on the page. And I guess I just want to be clear about what that factor in the sort of five-factor balancing test really is. Is it located in a place that a consumer is likely to see it in a transaction? The Second Circuit has talked about that in a couple of different cases. The Schnabel decision is one. It said that you have to put the terms and conditions at a place and at a time in the transaction when the consumer is likely to associate it with making a purchase.
Why? I respect the courts that have developed this five-factor test, but it seems like an unavoidably factual question in which parties are asking or courts are volunteering to act as reasonable consumers. What's your best case for treating this page, the disclosures on this page, as sufficient as a matter of law? It seems like you're asking us to go further than any other court has, but
Yeah,
maybe I'm missing something.
No, I think, Your Honor, I think Meyer in the Second Circuit is probably the closest. It's the Uber case.
But that's a tiny little, simple little screen on a phone as compared to this much busier.
No, it certainly has more to it, and I think you're right, Your Honor, that there's a significant difference between phone screens and either app displays or websites rendered on phones and websites. I think you're right, Your Honor, so let me answer that two ways. I think you're right, Your Honor, that there is no case that is presenting a website that looks like this. I think, Judge Kirsch is right. This is not the visually bewildering Nicosia screen from Amazon. It's also not exactly the sort of the display you have in Meyer, but I think that when you transpose that framework or that screen onto a web platform, I think that significantly similar. For example, there really isn't a lot going on here. This isn't, again, the visually bewildering Amazon screen. Even to Ms. Gold's point about the location of the disclosure, even in Meyer, it wasn't directly below the button. You had register for your Uber account, and then right below that is link to your PayPal account and link to your Google Wallet account. And then below all that, you have the disclosure, which again, when you're talking about a 3-inch phone screen.
Yeah, but there's also this problem. I've got to say, what this is doing at the end of a paragraph about gift cards is, I assume that your client uses consultants to help with user interface design.
That's beyond the scope of my knowledge.
Probably
how they
not in the
design
record.
website. One can assume that that's not someone just sitting in a room somewhere.
And what I'm thinking is, I assume this was a pretty thoughtfully designed user interface. There are lots and lots of considerations that go into that. And my guess is that making sure the consumer knows there's an arbitration agreement here is a relatively low priority in that design. Certainly that's the way it appears here. So why not just treat this as a factual question? Yes, it may be expensive, but if the stakes are sufficiently high, rather than having us try to play amateur average consumers.
Yes, Your Honor, I do hear that question and that concern. It's I think, again, 2 answers. One, or maybe 3. So again, Ms. Domer hasn't asked for that, hasn't asked for this to be treated as a factual question. Everybody agreed that the facts are undisputed, and in a lot of, I guess, the distinction between something that's fact-intensive, which this is certainly fact-intensive, but still undisputed. There are no disputed facts here, and the question is just at the end of the day.
Applying a 5-factor balancing test as to how a reasonable consumer is likely to respond to this is, as a matter of law.
I understand that, Your Honor. But for better or worse, that's how the courts have treated it, including this one. And there are lots of, I understand, lots of factual issues that are at issue here. You're balancing them all. But at the end of the day, it's like with a lot of things. Do the undisputed facts add up to a particular tort, reasonable notice, what's a particular state of mind? And it's just a question at the end of the day. Does it clear that legal threshold when you add those various facts up and you balance them against each other? I do want to spend a little bit more time, if I can, Your Honors, on the proximity point. Because, again, I think in Ms. Domer's brief, it really gets boiled down to, is it next to the button? But that's really not what the factor is. Is it, as Judge Peterson found below, or said below, is it linked to the transaction in a way that is going to be within the flow of the transaction? It's not something that's buried in the copyright bar down at the bottom of the screen. It's right below your payment and billing information, where, as he noted, users are going to look at before they say, here, charge my credit card, to make sure they've put in that information correctly. We haven't, I don't want to jump from enforceability to scope, Your Honor, but if you have no other questions.
You don't have an issue about scope.
Okay. All right, fine. So,
in my opinion.
So I won't spend more than a moment then on scope. I just wanted to note that in Ms. Domer's reply brief, she notes the theory that there are 2 contracts here, not one. In the district court, she refers to the contract singular. In her opening brief in this court, page 38 expressly acknowledged that the arbitration agreement covers the purchase contract. She's pivoted in her reply brief. I just wanted to note, since we had briefed in response to that argument is waived and not fairly before the court. But unless there are other points on enforceability, I'll say that we just respectfully request.
Would this be characterized as between a click wrap and a browse wrap?
Yes, I think that's right, Your Honor. I think you can, I mean, again, I think you can, depends what you mean by click wrap, I suppose, because you do have to click, but yes, I think it's in that odd no man's land between the click wrap and the browse wrap. It's certainly not a pure browse wrap agreement, because there is a disclaimer and a note that you have to take some action to signify your acceptance, but it's not, it's also not the click a box that says, click here to signify your acceptance. And I do think that at the end of the day, I guess one more point, Your Honors, that's the ultimate ending place of Ms. Domer's argument here, is that if the argument that, well, you could have done it better, you could have put it right under the button, that lands us eventually, when you ski to the bottom of that slope, you land in a place where checkbox is the only way you can do it, because you can always do that. But that's not the question under Wisconsin or any other state's law that we're aware of. It's just, was there reasonable notice? And given all the facts and circumstances that are undisputed here, there was.
Thank you, Mr. Tatici.
Thank you, Your Honor.
Ms. Gold, we'll go back to you now for rebuttal.
I just want to pick up where you left off, Judge Brennan, as to whether this is click wrap, browse wrap, or something else. As we all know, click wrap is generally enforceable. That's a way to secure assent. Browse wrap is generally unenforceable. We're not aware of any cases which have held browse wrap to be enforceable. This might be termed something called sign-in wrap in the case law. Because it has this sentence, by submitting your order, you accept our terms of order, but we're not aware of any federal appellate authority when that sign-in wrap is entirely disconnected from the button that you're actually clicking to submit the order. And it read in the context of this paragraph, as you pointed out, Judge Hamilton, you could actually interpret this sentence to mean by submitting your order using a gift card, you accept our terms of order. It's not at all clear that simply by clicking this big blue button, you are agreeing to the terms of order, which are also not even contained in that actual sentence. They're below that in green, which the rest of the page contains several green fonts as well, making it also inconspicuous.
Thank you, Ms. Gold.
Thank you.
Thank you, Mr. Tadici. The case will be taken under advisement.
Thank you.
Doesn't the podium will go down. Okay. Can you all help him? With the, doesn't it lower?
No.
There we go.
Oh,
Okay, we don't want to hurt anybody.
That's
but-
fine.
Okay, okay.
The court will call Appeal 23-1165, Luz Maria Arroyo versus Volvo Group North America LLC. We'll begin with oral argument. Mr. DeRose, from you.
thank you, Your Honor. Judge, as I lay getting ready for this in bed last night, I thought back to my law school days. We read all those cases and the judges were the boss. What the judges told us to do is what we learned to do. And I tried to practice that all my life as a trial lawyer. And then when I finally was coming up to these hollowed halls, I stopped and bought an Ickle book. And it had a chapter in there by Judge Prentice Marshall. And he went on and on and on about the honor to come before the Seventh Circuit. I've never forgotten that. I only come up here once in a great while. And when your honors talk, I not only listen, I obey. This case is screaming at us, Judge. We had his honor was wrong. Your honors told us what they wanted us to do. I put that whole one page of your instructions to us in my reply brief. And I went on, Judge, I would tell his honor, just keep reading what the court has said. And his honor did a great job in that first trial. And he even said on the record, I'm trying to be fair to both sides, but I'm doing what the courts tell me. And I thought he did a great job. And Judge, I only asked the jury for $1 million. And when they listened to what your honor said, they could listen to all those emails. They came back and said, DeRose, you're wrong again. she gets $7.8 million. I went away, I was shocked. But the more you think about it, Judge, as you have told us so many times, you give us the rules, we try to follow them as best we can when we walk into that courtroom, so we never have to come back again. And then what happened? The jury rules. They don't have to agree with me.
Mr. DeRose, could I ask you, we've read your briefs. You seem to be asking us to reinstate that first jury verdict. There are two insurmountable legal obstacles, I believe, to doing so. One is the $300,000 cap on compensatory and punitive damages under the ADA. And the other is the bar, the USERRA, the law protecting service members' employment rights, does not provide for punitive damages or compensatory damages at all. So I don't see how we could possibly do what you're asking us to do. What am I missing?
Judge, I do believe that when they put in a general verdict,
So you're going to the waiver point.
yes, Judge.
I looked at the verdict and I don't see that. I see a special verdict form that lays out different questions under the two different theories. And then, and we also see Congress tells us we cannot tell the jury about the damage caps, right?
Yes, Your Honor.
So I don't see how there's a waiver of the cap.
Well, Judge, I thought that Judge,
Dow?
no, not well,
Caney?
excuse me, Judge. Judge Easterbrook said, you know, when you say quiet and you let this all go to the jury the way you do.
And you're talking about the Powell's case?
Yes.
Yes, I understand the point, but I don't see how those facts match up with what happens here with the special verdict form and a statutory cap that you don't tell the jury about.
Your Honor, all I can say is I only dealt with what they put before me at the time, and when the jury said this case, and it was much more severe than just one of those two counts. That lady went through heck, as the Seventh Circuit told us. It goes all the way back. They said, we got a business to run. You're our only reservist. We're not gonna, we don't wanna make exceptions for you. She changed units, Judge, and ran the risk, and she suffered from having to go back for a third deployment. She did everything they asked him, and then she's 1 minute late. I think the jury was so offended by that. She signs in an hour earlier every one of those days. And they go back and by hand they change the time cards to make her 1 minute late. This is the kind of thing the Congress said, if they're not following the law, you can hit them for punitives, you can go after them. This is a case screaming at us. The panel that heard this case last time said, if we're wrong, DeRosa said there's no other reservist in your whole company, 500,000 employees in America. And how many employees? This is one of the biggest companies in the world, Judge. And if they said if we're wrong, send us a letter. Tell us that you have others. They never sent you a letter. Why? Because that was the only employee, and they said we're not firing her because she doesn't do her job. We're not firing her for issues of production. We're not firing her because she is disrespectful. We're not. The only thing we're firing for is not following this local attendance policy where you gotta be ready to start when the bell rings. Judge, I walked in here, rolled in here way late today, and I'm sorry traffic was what it was. All of us go through times in our life when we're 1 to 3 to 5 to 10 minutes late. You gotta be human. That jury knew that.
Thank you, Mr. DeRose. Would you like to reserve the remainder of your time for your rebuttal argument?
Yes, may I please, Judge?
Yes, very good.
Let me just get this out.
No problem. Thank you.
Thank you.
Mr. McMahon will now move to you for argument on behalf of the appellee.
Thank you, Your Honors. Good morning, and may it please the court. My name is Bill McMahon, and I represent Volvo in this case. And Judge Hamilton, I actually want to address your point first regarding the Pals case. Your Honor is absolutely correct. That has no applicability here. The jury verdict was in regards to compensatory damages under the ADA discrimination claim and punitive damages under the ADA discrimination claim.
So Judge Dow found that that a whole new trial was required, primarily on the theory that the verdict was driven by passion. Why isn't it at least equally likely that this jury was simply deeply offended by the expressions of disrespect by your client's management for the plaintiff's military service and sacrifices she had made for this country?
Your Honor, I'm going to answer that directly. It's because in this particular case, the adverse employment action being challenged was the termination of Ms. Arroyo's employment, not the conduct that may have occurred to her during her employment.
Do you think the jury was required clearly by the instructions to separate that out in deciding about the motives? I mean, that's asking a jury to draw lines that maybe judges can draw, but folks unburdened by a legal education might not.
Well, Your Honor, what they were required to do if they were going to award damages on the ADA claim is they were required to award damages stemming from the termination decision. And what happened in this particular case is the plaintiff took about a week to put on their case in chief. On a Friday, we go into the charge conference.
I'm aware of your theory.
Right.
And I know about the offer to put on more evidence to support compensatory damages.
Which was
declined. I would think this would also have easily supported punitive damages on these facts if there is liability under the ADA. I know that's a separate issue.
Correct.
But if you have liability, given all of these disrespectful, mocking emails about this woman's service for this country, I can easily see a jury being deeply offended and saying, yeah, punitive damages are appropriate for this.
Your Honor, given the evidence that was before the jury and the amount that was awarded in regard to the amount, especially that was requested in closing argument.
We'll talk about that in a moment, but
right.
Go ahead.
Right. Yeah, Your Honor, that was kind of it. That was one of the points that Judge Dow emphasized was it's disproportional, right? And if there's $1 million requested in closing argument and the jury comes back on the ADA claim with $7.8 million total, Your Honor, that is very strong evidence of passion or prejudice.
Or maybe the plaintiff just didn't ask for enough.
Well,
I mean, we don't tell the jury, we give them no guidance, right, as to what those numbers ought to be.
That's
we
correct.
don't tell them about the statutory cap. People in off the street have read newspaper articles about big jury verdicts before. Who knows where that number comes from? But there's certainly plenty of offensive behavior by Volvo management in this case.
There may be offensive behavior, and the jury may think the behavior is offensive, but ultimately they have to tie the behavior back to the adverse employment action being challenged. And that is the termination of employment.
How clear do you think that was in the instructions to the jury?
Your Honor, we do think it was clear in the instructions.
Where?
And, well, Your Honor, what I was going to say in regards to the instructions is, well, first of all, in the verdict form itself, Your Honor, but also on a related point to that, Ms. Arroyo did have a separate claim at one point in time for intentional infliction of emotional distress based on the in-term conduct that occurred to her, right? So it was based on the comments, and she made a very specific articulation of that in her amended complaint. I believe it was the third amended complaint, where she challenged those events that happened during her employment. Well, that claim was actually dismissed on summary judgment, and that claim was affirmed by the first Seventh Circuit panel.
Right.
Right. So all that was left for the decision at the time of the trial was the termination decision.
Yeah, but I'm looking at the damages instruction. And I don't see that, a clear instruction that says don't look at how she was treated during her employment. It just says consider physical, mental, and emotional pain and suffering she's experienced, right?
Right, but of course...
No evidence of the dollar value, et cetera, has been or needs to be introduced.
Right. We understand, Your Honor. And Your Honor, those instructions came from the Seventh Circuit.
Oh, I know.
Instructions.
But,
Right.
Sure.
Right.
But the question is the validity of the reasoning that these big numbers are evidence of a jury wildly out of control as opposed to just appropriately offended by an employer's violations of the law as the jury was permitted to find.
Well, I think there's two factors here. I think there's the conduct by the defendant, which clearly the panel said, this court's previous panel said, that's coming into evidence that can be considered. But then there's the effect on Ms. Arroyo, right? And it was the effect on Ms. Arroyo where there was not any evidence. But even if there were, another factor that Judge Dow relied on is saying, the amount awarded here is completely out of proportion to other cases in this circuit where emotional distress damages has been admitted
and that's the kind of reasoning that would allow a judge to impose a remitter, right?
Well,
and we've got a statutory cap here anyway. But I'm really struggling with the idea that that 2.6 million in compensatories
yes,
shows a jury wildly out of control. I mean, Congress obviously wouldn't have been too shocked by this number. That's why they put the statutory caps in, right?
Well, the statutory caps are in place based on Congress's determination, Your Honor. But even to get to a statutory cap number, there still has to be evidence of emotional distress suffered by Ms. Arroyo. They did not even ask her a question at trial. How did this affect your life being terminated by Volvo? They didn't even ask that question. They could have asked that question. They didn't. They didn't put on any sort of medical evidence of impact on her. They didn't put on any sort of evidence of family members' testimony on how her lives have been changed. That is the sort of evidence that the courts look at and validate when there is an award of emotional distress damages. So, Your Honor, for those reasons, we don't think it was an abuse of discretion. And that is the standard of review here as well, is abuse of discretion.
Sure. But can I go back to the discussion we were starting about the closing argument?
Yes.
Is it your view that a plaintiff's specifying an amount in closing argument caps the awardable damages?
No, Your Honor, it's not.
Of course not.
It's not my view that it caps it. It is our view here that Judge Dow properly exercised his discretion in saying the amount they came back with was so disproportionate to what they asked for that is evidence of passion or prejudice. And we cited a case from the Eighth Circuit, the Dossett case, which I think is kind of on point there. In Dossett, there was a request of $500,000, and there was an award of $1.5 million. And in the district court in Dossett, there was actually a sua sponte, kind of the district court bringing this up, saying, look, this is completely out of proportion here. I want to talk about a new trial, and a new trial was granted at the district court suggestion. So if we're talking about a 3-to-1 ratio, and here we're talking almost about an 8-to-1 ratio, when you factor in the punitive damages, that was a proper exercise of discretion by Judge Dow.
Do you think the district judge was required to order a new trial, as opposed to a remitter, or just impose the cap?
On these facts, absolutely, Your Honor. Because if there is an irrational verdict, which is a product of passion or prejudice,
if there is, that's. But the question is,
right.
Was that a call that could have gone either way here. I think it could have.
Well, it maybe could have, but Judge Dow properly exercised his discretion in finding that it did. And since he found that it did, he relied on the case law from this circuit that said remittitor would not be proper, and that a new trial in its entirety would have to be granted. And Your Honor, that's ultimately what we get down to, is the fact that the mandate from this panel was filed in the first trial. Judge Dow was dealing with the evidence that came in at that trial, and then the verdict that was returned, and he properly exercised his discretion in factoring in all of that evidence, all the testimony, and ultimately granting the new trial that he did. And so for those reasons, we ask that the district court be affirmed.
Thank you, Mr. McMahon.
Thank you.
Mr. DeRose, will now go back to you for rebuttal argument.
Thank you, Your Honor. Your Honor, there's so many things you'd like to say. That jury never asked us any questions. They were never confused. They sat quietly. They listened to the evidence. They weren't impassioned. I wouldn't even be able to tell you what one of them looked like today. I wasn't looking at them. I was looking at the evidence. And when I suggested a million, that's a suggestion. I did that with Judge Grady years before that, and Judge Grady, the jurors in that case said, Judge, are we limited by what DeRose is asking for? And he said, no, he's only giving you a recommendation on what he thinks. I guess I never asked for enough. But I've had it before, Judge, where they say, no, you're just out there giving them advice. This is a fact question. And this thing about the ADA, we entered a stipulation which Judge Dow would not allow in that second trial, that PTSD is a disability. This lady was going through heck in the courtrooms. I mean, and what is the last word that Schroeder says when he fires her? He sends the email to his boss and says, she's been a pain. She just wants ESGR to always help her every time she has. That's her right. And ESGR was mad at her. She gives them an award for being a great company. With baloney, Judge. She was doing everything she could to say, just take care of us. She's an HR person, and she knew what her rights were. And maybe that's more dangerous. If she didn't know all that, she would have, but she was a good worker. They were terrible what they did to her.
Mr. DeRose, any final thoughts for us?
Just God bless you and do the best you can.
Thank you very much, Mr. DeRose. Thank you very much, Mr. McMahon. The case will be taken under advisement. We are now going to move to Appeal 21-2860, David Schlem versus Brendan Pizzala et al. And Ms. Zhang will begin with you for our oral argument on behalf of the appellant.
Thank you, Your Honor. And may it please the court, Alexis Zhang for plaintiff appellant David A. Schlem. The district court dismissed Mr. Schlem's complaint as untimely on the theory that because he had failed to properly exhaust his administrative remedies, he could not avail himself of tolling for the time spent exhausting. And although the state relied exclusively on that theory below, it now concedes that it was wrong. Mr. Schlem did properly exhaust, and he is entitled to tolling. That recognition should compel reversal of the decision below. The operative Wisconsin tolling statute provides that when the commencement of an action is stayed by statutory prohibition, the time of the prohibition does not count towards the limitations period.
How similar is the Wisconsin statute, Ms. Zhang, to the Illinois statute?
It's materially identical.
And we've upheld that, is that correct?
Yes, so in Johnson, this court said that that statute allows for tolling during the exhaustion period of a Section 1983 claim. And so, given that the state has conceded that Mr. Schlem did properly exhaust and is entitled to tolling for the period he spent exhausting, then we think the court should accept that concession as a premise for its decision-making rather than going into the exhaustion analysis itself. And once you start from that, then
Should we end there?
yes.
I
So
mean, I'm just wondering, how far do we have to go to decide this case? Should we just issue, is it your position we should just issue a 2-sentence order that says the appellee has conceded your argument and waived any other statute of limitations argument?
yes, we think
That's it.
the court could do that, and it would be a very simple resolution to this case.
But we've got some conflicting, non-precedential language, right? And so there might be some value to sorting this out, in particular as to the state's 6-day exception that they're arguing for, right?
I mean, we think that the issue is not preserved for the reasons that we've stated in our brief, and that if you think the state is right on the interpretive question, it still would require reversal. But to the extent...
I probably don't, but think they're right about that, but we'll talk about that in a moment. But at least the statute seems pretty clear to me. But it might be helpful to actually tell district judges and departments of correction and prisoners how this works.
I mean, I think that this case is not a great vehicle for doing that, given the factual issues that would remain even if you resolve the case in the state's favor. But to the extent that you want to talk through the merits...
I'm not suggesting resolving it in favor of the state. I'm suggesting that you are correct about when the tolling stopped. That
yes. So I think that follows from the language of the
exactly
tolling statute.
the plain language. Mm-hmm.
Yes. And so I think that's why when the Wisconsin Supreme Court described that statute in the Colby case, it described it as saying that the statutory prohibition, tolling provision, means that the statute of limitations period doesn't begin to run until the end of the statutory prohibition. And so here, that should cover the pre-filing period that the state takes issue with. The PLRA exhaustion bar precludes suit before the prisoner files his administrative grievances, just as it does while the grievance period is ongoing. That's why if Mr. Schlem, instead of filing his grievances, had come straight to this court, the state would be here telling you that he hadn't properly exhausted, and the PLRA acts as a bar to his suit. And so under Colby, under Johnson, that's a statutory prohibition. And to the extent that this court reaches the merits, it means that the court should reject the state's interpretive theory and reverse the decision below.
Jane, could I ask you, can you shed any light as to why it took Mr. Schlem so long to file his action? We have an exceptionally long statute of limitations under Wisconsin law.
I think Mr. Schlem's motion to dismiss briefing below suggests that there is a delay in him receiving the final decision. But at the same time, I also think that the specific reasons for his delay aren't relevant for purposes of the statutory tolling analysis. The state cites a number of cases in its brief that come from the context of equitable tolling, where delay in filing suit can be a barrier to tolling. But again, the language of the Wisconsin tolling statute just asks whether there's a statutory prohibition in effect that would preclude suit. And to the extent that there are cases where delay is egregious or unwarranted, then I think latches would still act as a defense that the state could raise to preclude any problematic results. But the state hasn't raised latches here, and so there's no reason for the court to consider any of that to the extent it wants to reach the merits of this case.
I'm not sure I agree that laches would be a defense independent of the statute of limitations, a timely action under the statute, but okay.
Yes, so under Wisconsin law, though, even if a statute of limitations period has not expired, the state can still raise the issue.
I
of
did not know that.
And so I think our point is just that the statutory scheme operates as a harmonious whole, that the state, at least in the period at issue here, gave prisoners and other tort litigants 6 years to file suit, and they should be entitled to all of that in addition to whatever period is they're prohibited from filing suit given a statutory prohibition, subject to, if the state wants to raise laches in other cases, it's free to do so, but it hasn't done so here. And so given all that, I think the state's absurdity arguments that it makes in its brief, the court should give that no weight. But ultimately, I think, however the court chooses to proceed, we'd urge it to reverse and remand, and I'd like to reserve the rest of my time.
Thank you very much, Ms. Zhang. That will be granted. We are now going to move Ms. Schmelzer to you for oral argument on behalf of the state.
Thank you, Your Honors, and may it please the Court. I'm Jody Schmelzer, an Assistant Attorney General for the State of Wisconsin Department of Justice, and I represent the defendant appellees in this case, who are all employees of the Wisconsin Department of Corrections. I'm going to first address whether or not Mr. Schlem's claims were timely filed, and I know with Judge Hamilton's comments I might have a little bit of a hill to climb here. But looking at this court's case law, looking at how the Wisconsin Supreme Court interpreted its own tolling statute in the Colby case, and looking at common principles behind statute of limitations and the federal exhaustion requirement for inmates, I think the interpretation of the statute that Mr. Schlem progresses is unreasonable. And his interpretation would toll the statute of limitations at accrual of the suit.
Ms. Schmelzer, let me ask you this. On January 18th, 2013, that's the day after the conduct report was dismissed. It's the first of the 6 days you rely upon. If Mr. Schlem had filed his civil action that day, what would have been the response?
The response would have been, it would have likely
You have not
evoked a motion
exhausted
for summary
under, you have
judgment.
not exhausted under 1997E, correct?
Correct.
The statutory prohibition remained in place. Given that, and the language of the statute, I don't see how you can fault him for not, how you can count that day against him or any of the next 5 days.
The statutory prohibition that was in place was federal exhaustion. He had not initiated or completed it by that date of Your Honor's hypothetical. If you look at this court's reasoning, and let's look back to, I guess, the Wisconsin Supreme Court interpreting its own tolling statute in Colby. There, Mr. Colby was in a car accident in March of 1990. It took almost 3 years for him to file a notice of claim against the Columbia County in that case. The Wisconsin Supreme Court did not toll our statute of limitations from the date of accrual, which was in 1990. What it said was, you're going to get the 3-year statute of limitations, and we're going to toll for 120 days. Had it told it from the date of accrual, like Mr. Schlem is arguing that this statute should be interpreted, there would not have been a statute of limitations issue there. So it said you get 3 years plus the 120 days. You get the statute of limitations plus the tolling period, which was 120 days. You don't get from the time that your injury accrued, the time that your claim accrued, which was, like I said, almost 3 years before he filed a notice of claim. So just looking at how the Wisconsin Supreme Court applied our tolling statute is not consistent with what Mr. Schlem is arguing here. And it also produces some absurd results. Under that interpretation, Mr. Schlem could have never filed an offender complaint or a grievance here, and the statute would still be tolled. And given that very generous statute of limitations at the time, it could be tolled while he's incarcerated, while he doesn't file any exhaustion, or whether he does so improperly, which is another issue here, and until he's out of prison. And then he gets the benefit of an entire 6-year statute of limitations at that, because he's no longer required to exhaust if he's no longer a prisoner. So that produces, I think, an observed result, an unreasonable result here that is contrary to what the Wisconsin Supreme Court says is the purpose behind our statute of limitations, which is to promote fair and prompt litigation, protecting defendants from claims brought after memories have faded and evidence has been lost.
Mr. Meltzer, an odd question for you. It's multi-part. Please stay with me.
Sure.
You may know this as a matter of Wisconsin administrative DOC regulations. For counting, is a year in the Wisconsin DOC 360 days or 365 days? And the reason it's a multi-part question is, might that be different for purposes of DOC registrars calculating when a prisoner may be released versus DOC responding to a complaint and the applicable statute of limitations?
I guess I'm not sure if I follow your Honor's question.
All right. Let me rephrase it. For purposes of counting a year under the Wisconsin DOC administrative regulations, if you know, is it 360 days for a year or 365 days for a year?
And when you say under the department regulations, do you mean our administrative code?
Correct.
And the context for that would be, I think, are we counting like the days they have to file a grievance or to file an appeal?
It would be just the number. And the reason I ask is if it differs, for a case that's on the margins like this, it could make a difference. It may be that the DOC says for you to file a lawsuit, a year means 365 days. But it also may mean for if you're incarcerated, a year is 360 days. That's the contrast I'm drawing. You may not know.
And I don't know that, Your Honor, but I don't think it really makes a difference here, because I think when we apply tolling to only the period that the inmate is engaged in the exhaustion process here, start when he files his grievance, ends when he gets that final decision. When we apply that, it's indisputable that Mr. Schlem is 3 days late. And that's given a generous, I think, time of accrual for him, which we in our brief, argued at the latest was the time of the disciplinary hearing. And keeping in mind, this is a retaliation claim. You don't have to have an overturned Connick report to bring a retaliation claim. As long as it had an improper motive when the...
Wouldn't you argue that there's a heck bar to such civil claims?
I don't know that heck applies in this case, because I don't believe there was any...
To a conduct report?
Right, I don't believe there was...
Discipline?
There was not any segregation time or any addition to his sentence or anything like that. So usually heck doesn't apply in those situations where there's not a challenge to the fact or duration of his confinement. It's just a Connick report. He might have some consequences in the prison setting, but it actually didn't affect the fact or duration of his sentence, to my knowledge. So here we have an undisputed and probably generous time of accrual here for a retaliation claim. We have an undisputed time when he signed his first offender complaint after that, which was January 23rd. And Mr. Schlem does not dispute the time, and he concedes that he received the warden's decision on February 22nd. And the complaint was ultimately filed almost 6 years later on February 19th. We do note, and Mr. Schlem did point out that his complaint might have taken a little bit of time to get filed. He actually signed his complaint and turned it over for filing to the prison staff on February 18th. So at most, that gets him 1 day, but still late under the applicable statute of limitations. So again, looking at why that calculation makes sense, we do see this court's decision in Hatch where it engaged in that same calculation process. It didn't start the tolling at the date of accrual. Instead, it looked at when the inmate first engaged in the exhaustion process. It said the clock stopped on that date for the statute of limitations, and it restarted on the date that the exhaustion process was over. We see other cases from this court following that calculation process. in Gomez v. Randall and Givens v. Lutke, and cases from other circuits like the Gonzalez case out of the Second Circuit. We also see several district courts following that calculation process. So in Your Honor's questions about why shouldn't we just remand this, I think it's important to set out and to interpret this tolling statute, which is almost identical from the Johnson, Illinois tolling statute to Wisconsin's. There's only a few, I think 2 words that are different, and in no material way different. I think it's important to set out when tolling begins for inmate exhaustion.
In this case, wasn't it correct, though, that Mr. Schlem tried to file a grievance right after the conduct charge was filed and was told it's too early? You have to wait until after the hearing?
That is correct, and that's exactly why we gave him the benefit of that and said, we'll start from January 17th, the date of your hearing.
Even though he could not have filed on the 18th?
He could not have filed on the 18th because he hadn't exhausted.
Exactly. The
Correct.
statutory prohibition remained in effect.
That statutory prohibition was in effect, and
But you say the clock was running.
because it's not told until he engages in that exhaustion process. Correct. The statutory prohibition is exhaustion. If he's not engaged in it, it's not told. I see my time is up, Your Honors. I'd ask that the court affirm the district court's decision. Thank you.
Thank you, Ms. Schmelzer. Ms. Zhang, we'll now go back to you for rebuttal argument.
Thank you, Your Honor. Just a couple of points in rebuttal. So first, on the statutory argument that the state makes, I would point out that the court in Colby limited the plaintiff there to 120 days because the tolling provision at issue there had a defined period of tolling of up to 180 days. Here, the statutory prohibition provision does not have any specified times included, and I think if you look both at the provision in Colby and the other tolling provisions in the subchapter of the Wisconsin statutes on statutory tolling, then you can see that the state, if it wants, can include those kinds of conditions and has included those kinds of conditions in other provisions. For example, there's a provision on tolling for mental illness that says indefinite but up to 5 years at most. And so the fact that the state has chosen that the legislature has chosen not to include any sorts of conditions or limitations in Section 893.23 should be probative here. And the state cites a number of cases where this court or district courts in dicta have referred to the limitations period as not including the period before an inmate files his administrative grievances. But I would note again that none of those cases engage in statutory tolling analysis, and a few of those cases are cases that come in the context of equitable tolling. And so given that, I think the court should look towards more fundamental principles of statutory interpretation, as well as how the Wisconsin Supreme Court in Colby characterized the limitations period as continuing until the statutory prohibition lifted. And then second, on the point of absurdity, I think I would point out that on the front end, there's a 14-day limit on when an inmate must file a administrative grievance, and so the pre-filing period at issue in this case is not going to affect very many cases, and to the extent that there is any issue on the back end, the state can invoke latches, which it hasn't done so here and hasn't disputed, could be applicable in other cases. And then finally, on the matter of equitable tolling, to the extent that the court would get into it, there are factual disputes, even if the state's position is correct, that would need to be resolved on remand. In particular, I'd note that, as Mr. Schlem explains in the reply brief, the record only states that he was mailed the decision that allowed him to be able to sue on January 17th. The record is silent as to when he received it, and he wouldn't have been able to file suit in this court before receiving and having knowledge of his ability to do so. And so whether on issue preservation grounds, on the merits of the state's interpretive theory, or on the factual questions that would remain if the state were correct, we'd urge this court to reverse and remand. Thank you.
Thank you, Ms. Zhang. You were appointed counsel. You have the great thanks of both the court and us as the judges here, to you and your firm for all the hard work. So thank you. And thank you as well, Ms. Schmelzer, for your presentation. The case will be taken under advisement.
Thank you, Your Honor.
We'll now move to Appeal 23-2355, Tamara Fraser versus Equifax Information Services LLC. And Mr. Zemmel will begin with oral argument from you.
May it please the court, my name is Daniel Zemmel. I represent Tamara Fraser, a plaintiff appellant. A credit report is inaccurate under the Fair Credit Reporting Act if it's either patently inaccurate or misleading in such a way that it has the ability to adversely affect lending decisions. In this case, Ms. Fraser's credit report was patently inaccurate. First, I'd like to go through how to read the credit report at issue. On page 10 of the appellant's moving brief, there's an image of the trade line in the credit report at issue. It has 3 columns, 30, 60, and 90 plus columns. What these columns represent is the specific month and year that a consumer is late on an outstanding obligation. The facts in this case are undisputed. Ms. Fraser had a short sale in January of 2016, and after that short sale, there was no outstanding obligation. That's why this circuit, addressing this trade line, and this panel specifically held it would be accurate for the credit report to not report any lates after 2016, the short sale that occurred.
Let me ask you this, Mr. Zemmel. Much of the focus of the briefing seems to be on the credit link report and how that got into the tri-merged report. Obviously, Equifax is the defendant in this particular suit. There was another lawsuit that Ms. Fraser brought against Credit Link in the Northern District of Illinois. That suit was settled and dismissed. The allegations in that suit, though, don't appear to match what was going on here. Is that correct?
The allegations in that suit are, yes, that's correct. A part of that suit was the inaccuracy, but there were other statutory obligations like Credit Link didn't follow. So we sue them for those reasons.
So as I understand it from the filings in the Credit Link suit, it was an allegation that there should have been a reference to Equifax, and there wasn't. The allegations in this suit are all the inaccuracies that Ms. Fraser says was present in the Equifax documents, correct?
No, Your Honor. I don't know what you're referring to with that.
Well, the joint status report that was filed in the Credit Link report, the case number is 22CV5226. The document entry is 15. Instead of investigating the error, Credit Link instructed plaintiff to dispute with another credit reporting agency, Equifax. Under the FCRA, Credit Link was to itself contact Equifax, provide plaintiff with a copy of her dispute rights, so Credit Link's conduct violates the FCRA. That was the gravamen of the allegations in the Credit Link case.
Yes.
Those are different than what we have here against Equifax, correct?
Yes, certainly, Your Honor. Sorry for the confusion.
Do we have, I mean, on page 10, I assume you're referring to, this is the Credit Link report, right?
Yes, Your Honor.
Do we have in our record the Equifax to Credit Link communication?
No, Your Honor. The only thing we have is the declaration from Credit Link that says they got it and it's everything Equifax gave us. There's no counter evidence.
Right. Is there any significance to the bold on page 10 of your, in the source, XPTUEF is in bold?
Yes. EF is Equifax,
Yeah.
and it's emboldening it saying this is the information that came from Equifax, or that's the key source. Here.
Consistent with the affidavit that you filed.
Consistent with the affidavit, also consistent with the Equifax, with their consumer dispute responses to Ms. Fraser that have these exact dates as showing late.
There's no dispute that they, I mean, at least I think, there's no dispute that they provided these dates to Credit Link. just like DMI did with that code 3. I mean, I guess the question that I have here is if you look at the Equifax information says that the loan was closed in January of 2016. And then they have that code 3.
Well, sorry, go ahead, Your Honor.
They had that code 3, which is the same thing we have in the DMI case. The code 3 closed in January 16th, and we decided that nobody could have been misled. It was actually 90 days late on those dates, but it had been closed in January 16th. The problem that I see here is, of course, the credit links report does not state that it was closed. The Equifax report says that it was closed. So you're trying to hold Equifax responsible for credit links report to the bank, not showing that the loan was closed. Is that the gist of it?
I think it's more than that, Your Honor. First of all, if Equifax didn't provide the date closed to CreditLink, that would be a problem. And consistent with CreditLink, the evidence here, that's what CreditLink says. With regard to...
CreditLink said they didn't get the date closed from Equifax? Because there's a weird thing here, okay, in the background, which is we've got very sophisticated financial institutions involved. And it seems extraordinarily weird to me that any of these financial institutions can say the last activity occurred in 2015, but she's still late on her mortgage payments in 2020. So, I mean, these banks, that's what I'm saying, you know, when CreditLink says, oh, no, we didn't know the date it was closed because Equifax didn't provide it, I'm not sure that that's what CreditLink says.
CreditLink specifically says it did not make any changes to the information it received from Equifax in their declaration.
Why not bring those allegations against CreditLink in the CreditLink case?
In the CreditLink case, we addressed the error also. I think there was an obvious error. There were other components that you brought too. But
the complaint doesn't say that. The complaint in the CreditLink case even says CreditLink left parentheses, quote, Equifax. It looked like the Equifax complaint hadn't been revised in the CreditLink case. I just don't understand, why weren't the allegations against CreditLink brought in that action?
I don't have that complaint before me, Your Honor. But this problem stems from Equifax. And I want to address Judge Kirsch's point because it's a very important point. I think there's an error that Judge Kirsch is mentioning here. I want to explain it. The 3 in the Dovenmuehl case is absolutely different than the 3 in this case. The 3 in the Dovenmuehl case on page 18 of the reply brief is in the pay rate section of the report, not in the historical section. The historical section in the Dovenmuehl case, it started with 3 in the request information, but in the response information, Dovenmuehl put the dashes in, which the circuit meant no response, which means delete the 3s in the historical payment grid. Equifax's case is different. We're saying the 3s on these months, July 20, November 19, these are dates she was 90 days late. That's inaccurate. Everyone knows she wasn't late on these dates. This report must be patently inaccurate. The district court, they found that the report was accurate by focusing not on the issue of these historical inaccuracies, focusing on whether the credit report is currently delinquent or not. It did so by talking about BIBs. BIBs addressed a different issue. We attached it as Exhibit 12 to the motion for summary judgment. The BIBs trade line spoke about the pay status and the pay status alone. And that data field didn't have a date associated with that status, and it was therefore ambiguous whether it was currently delinquent or historically delinquent. In the payment history section, the payment history grid on the BIBs trade line, there is no claim of inaccurate reporting during specific months. And also, the reporting of the specific months stops by the date closed. The same thing was addressed in the Gross case in Exhibit 13 of the motion for summary judgment. Again, it was a pay status issue, not inaccurate historical delinquencies. That's what we have here. There is no question Ms. Fraser wasn't late in 19 or 18, but this report specifically says she was. The report's also inaccurate under the misleading standard. Below, we presented evidence from the mortgage broker and from 2 expert witnesses that these recent lates have the ability to impact lending decisions. And in fact, in Ms. Fraser's case, it did impact the lending decision.
And here's where we've got this issue about the loan officer initially saying one thing, the underwriter saying later on that, that it was her student loans issue. It wasn't it was the debt to income ratio. It was not the previous lates, correct?
Yes. There are competing issues of fact in that. But
Well, I don't know if I agree with you on that. There's a statement by the loan officer, then the loan officer and the underwriter later on say, no, that wasn't really what was the issue.
I thought this was addressed by the difference between automatic and manual underwriting.
That's correct. She lost 7% of a ratio because of this.
Although you indicated in your reply brief that her ratio was above what it would have been for mandatory underwriting, then the underwriter talked about the fact that that would have been affected, that ratio would have been affected here. We would have had to get to mandatory underwriting.
A mortgage broker's job is people come to them and they don't get signed off on a mortgage. They have to work the process. Do this, do that, to pay this debt as part of the closing, and we're going to get you that loan. That's standard procedure. And our expert says the issue here was $1,200. That would not stop Ms. Frazier from purchasing a home. The 7% is significant. A $15,000 difference, that's something that would stop a loan. We have expert opinion on that, and so the damages component of this case has question of fact. But with regard to accuracy, whether it's the income issue or the lates, it's misleading because it has the ability to impact the lending decisions.
We're going to grant you some rebuttal time, unless you have a question. No. Thank you, Mr. Zemel. Mr. Conover will now move to you for an argument on behalf of the appellee.
Good morning, and may it please the court. Kellum Conover for Appellee Equifax Equifax Information Services, LLC. So I just want to make 2 points in response to the colloquy that you had with my friend on the other side here. First, there are 2 claims at issue here. And under the Section 1681I claim that Ms. Frazier brought, that claim is focused on the accuracy of Equifax's credit file. For that particular claim, the court needs to look at what was actually in Equifax's credit file, which was provided to Ms. Frazier in the consumer disclosure that Equifax provided her. So for that claim, the basis for that is going to be the Equifax report itself. And for all the reasons we listed in the brief, and I'm happy to go through them here if the court has questions about it, we don't think that there is any triable issue as to the accuracy of the Equifax report itself. Now, as to the second claim, the Section 1681E claim that Ms. Frazier brought, that concerns whether Equifax provided to a third party a credit report that was inaccurate. And here we get into the problem that we don't have in the record the report that Equifax provided. Instead, Ms. Frazier is trying to infer what Equifax provided based on what CreditLink ultimately ended up reporting. And we don't think, as a matter of law, that that's appropriate in this case.
Why is it? Let me ask you, you say the only evidence in your brief, the only evidence of what Equifax would have actually reported to third parties comes from the disclosures it sent Frazier, which reflected Equifax's file in her account. What about the Bodner affidavit?
So, thank you, Your Honor. So the Bodner Declaration, and this is in District Court Document 113-1. I'm looking at page 2, paragraph 4 of it. So my friend on the other side did not actually quote what the Bodner Declaration says. This is what the Bodner Declaration says. It says, quote, without altering any of the information provided by the nationwide consumer reporting agencies, meaning Equifax and others, and then it goes on. So what the Bodner Declaration speaks to is whether the specific numbers were changed. And we don't dispute that the numbers are the same. If you look at the Equifax consumer disclosure and what was in its credit file, those are the same numbers that are ultimately appear in the CreditLink report. The issue, and this is something that the Bodner Declaration doesn't speak to at all, is whether CreditLink ended up reporting all of the same information that was reported to it by Equifax. And this goes back to Judge Kirsch's question about there seem to be discrepancies here. Equifax included in its credit report the date the account closed. Equifax also included the date of the last payment in September of 2015. Equifax included...
I understand your position is nobody could have been confused by this, but apparently, ultimately, the mortgage company, Mutual Federal, was confused by it and understood it the way so as to prevent plaintiff from getting the mortgage. What I'm trying to understand, was there a discovery request to you all in this case that would have included the communication that you had to CreditLink?
So two things, Your Honor. One is that just as a matter of practice, Equifax does not keep records of the particular reports it ends up sending to third parties.
Not available?
As far as I'm aware, no.
So the best evidence available is what Bodner tells us here.
Right. So it seems as if CreditLink might actually have a copy of that because they can know that they did not change any of the information.
But
there.
you all didn't. You didn't get it. They didn't.
Your Honor, that's not our burden. It's Ms. Frazier's burden to raise a tribal issue here.
This is the evidence we have.
But that is the evidence. But also, I don't think that the record is as you stated. So the uncontroverted record here is actually that the bank was not misled by the CreditLink report that it received. This is coming directly. This is supplemental appendix page 30. This is the Holmes Declaration where the loan officer himself testified that according to the disclosure, quote, Frazier settled her account for less than full balance in or around October of 2015. And he goes on to explain why that's the case. It's because the CreditLink report that Mutual Federal Bank reviewed also included the date of last activity. It also said that the account was paid for less than full balance and that the current amount was actually $0. If there were any question about this, and there isn't, but if there were, Frazier's own purported expert, Mr. King, also expressed his understanding that he did not think that the bank was misled in this situation. His deposition testimony was that Oakleaf, meaning the bank here, quote, did understand the situation. And if you'd like to consult the record here, that's District Court Document 86-18 at deposition page 97, lines 14 through 18. So the uncontroverted record is that the people who actually ended up reviewing this, the CreditLink report were not misled by it. And this even goes to the opinion of Mr. King himself. His opinion was not that this report affirmatively misleads anybody and gives the misleading impression that that Ms. Frazier was either delinquent or made late payments years after the account was closed. It's instead that, well, it gives rise to two different interpretations, so we don't really know what would have happened here. But if a reasonable reader reading a report couldn't decide what the proper interpretation is, that doesn't mean they're misled. It just means they don't know. And that's precisely...
Is there any doubt that the Equifax report to CreditLink showed 90-day delinquent payments for 3 dates within 12 months of the time she applied for the mortgage?
There is absolutely doubt in that, and that's because...
Okay.
If you look at how Equifax recorded this information in its file, and this is again going back to the special appendix page 6, which is just the Equifax, page 6. Special appendix page 6. If you look at, this is the consumer disclosure form in Equifax's files. The way that they recorded the account status with a status code of 3, that indicates that on each of those dates, the account was 90 to 119 days past due. I mean, that's what the status code means. What Equifax meant by that was that it was essentially repopulating the current account status.
What do you mean that's what we meant?
Mm-hmm. So, as you may recall from the Dove and Mule case, when Dove and Mule was filling in its grid and was putting dashes down for certain boxes, it was basically creating a current status and putting a dash, and whatever Dove and Mule meant by that, that's an invalid reporting code. And the record
That's the Willis testimony.
Correct. And so if you look at the Willis testimony, what Equifax does in those situations is then it populates it with the current account status and foreclosed.
And that's the source of the problem here, right?
That is the source of the problem, Your Honor, but that doesn't mean that the Equifax report itself was misleading. It simply means that given all the contextual information, including that the account was closed in January 2016, the date of last payment was in September 2015, and that the account was paid for less than full balance, somebody reading this would understand it to mean that that was essentially what the status of the account was when it was closed.
Let me try again from a different angle. I'm troubled here. Do you think we made a mistake by letting Dove and Mule off the hook?
don't think that, I think that
Because what,
ultimately the concern here is the credit link report, right? And so Congress would make credit link liable for any inaccuracies in that report. Ms. Frazier simply has not shown that
well,
what Equifax.
Bodner says we're reporting what we got from Equifax.
Bodner says that
And
they did
that's,
not alter
it is
the information.
patently false in saying that she was 90 days late on those 7 months, including months within the year look-back period from the mortgage application.
So, Your Honor, if
right?
I may try again to answer your earlier question about why the Equifax report itself cannot possibly mean what you just said. If you look at it, you would expect to see different delinquency codes reported on each of those dates. It's saying, for instance, on October 2019, that the account was purportedly 90 to 119 days past due. 30 days later, or 31 days later, in November, there should be a different status code for 120 to 149 days. There isn't. It's the same status
Well,
code.
who knows what happened, right?
Well, no,
there are
but-
many things that could have happened. Partial payments, intervening payments, who knows? I mean, this is the kind of situation this act was designed to protect people from.
Your Honor, we understand that this may not have been as clear as.
That's putting it mildly.
Yes, but the question is ultimately whether a reasonable reader would be misled into thinking that her account was delinquent. And they would not be, because they would see that these codes can't mean actual delinquency dates, because if they would, different status codes would have been used.
So what you're saying is that somebody paying close attention with a lot of experience in the business would have understood this must be wrong, right?
May I, Your Honor?
Please.
Yes, and the reasonable reader standard.
That sounds like patently false and inaccurate.
With respect, Your Honor, no, because the status codes themselves cannot actually, you would expect to see additional dates of delinquencies, or you would expect to see different status codes actually used if, in fact, they meant actual dates of delinquency.
It must be wrong. What am I missing here?
No, it means that the interpretation that Ms. Frazier is trying to assign to it is not an interpretation that a reasonable reader would take.
What's the better interpretation?
The better interpretation is that this account history reflects the account history, and that at the time the account was closed, it was 90 to 119 days past due, which is undisputed in this case.
Okay, then why doesn't it report 90 days late for every month after 2015?
So again, the reason this particular issue came up is because every single time that Ms. Frazier requested an investigation into these codes, Equifax would go back to Devamule and say, hey, what's going on here? Devamule would provide an updated report that included a new status for that particular month, and the status ended up having those dashes. Equifax's system says that's an invalid code, so we'll replace the dashes with the current account status. Current account status is not misleading information, it's just the current account status.
But
And
it's
so,
understood as saying she's 90 days late on those payments, those months.
for a closed account, it indicates that the
Yes.
account was 90 to 119 days past due.
I have yet to see a theory on which this is not inaccurate, but I think I understand your point, but maybe not.
Mr. Conover, is it a fair summary? Credit Link said they did not change Equifax's info. That doesn't mean Credit Link included everything Equifax sent Credit Link.
Correct, Your Honor. Yes.
All right, thanks very much, Mr. Conover. You've gone over your time. We're going to give the same time to Mr. Zemmel. Mr. Zemmel will give you 3 minutes for rebuttal.
Thank you, judges. What Equifax is arguing here is the misleading standard. We're not even at that point. We want to start with patent inaccuracy. The information's patently inaccurate. The holistic approach of looking at dates closed, that's not necessarily the standard. It's also misleading, but it's patently inaccurate. That's exactly what Mr. King, our expert, focused on, and we did it in the context of the HUD guidelines. The HUD guidelines say if there is a late within 12 days, within 12 months of the mortgage application, they can't get a loan. And that's exactly what this credit report says. So it certainly has the ability to mislead, which is all that's required under the Act for accuracy. With regard to whether Equifax presented information to CreditLink, we have the best evidence here. The best evidence is the declaration from Bodnar. Equifax hasn't rebutted that evidence. If they've done so, they've done it only through argument of counsel, not through evidence. On summary judgment, the facts need to be taken in our favor. And on the record, that information came from Equifax, and Equifax's own documents show they reported Ms. Fraser as late during specific months of the month and years of 19, 20, and 2018. I also want to talk about Dovenmule for a moment. Dovenmule, this circuit held, fixed the status codes. When they wrote the dash, they removed the 3s to be no reporting, to then remove this exact type of reporting, which is 90 days late in specific months. Equifax didn't do that right. They didn't remove those codes. Those codes remained, and there's no question this credit report, whether it's the consumer response to Ms. Fraser or the report that CreditLink published to Ms. Fraser's creditors, that report says she was late in 2018, 2019, and 2020. A reseller gets credit reports from the sources and resells those reports to the lender. That's what a reseller means. And to impose liability on resellers, it will change the statute to impose the accuracy requirement on them instead of to the CRAs. And for those reasons, I think the lower court should be reversed. Thank you for your time.
Thank you, Mr. Zemmel. Thank you, Mr. Conover. The case will be taken under advisement. We are now going to move to Appeal 22-3282, United States versus David Perez, and Ms. Singer will recognize you first for argument on behalf of the appellant.
Thank you, Your Honors. Good morning. May it please the court, counsel, my name is Dina Singer, and I'm counsel for appellant David Perez. Mr. Perez's criminal case is before this court following a probation revocation hearing, supervised release hearing, where the district court questioned the probation officer about the alleged supervised release violations, and then denied Mr. Perez the opportunity to cross-examine the probation officer on the same issues.
What would he have asked?
I'm sorry, I did not hear your question.
What would he have asked? What are the questions for the probation officer?
What I would have asked, I was the counsel at that time.
I know, but what would you have asked?
I would have-
Because Judge
Sure.
Seeger, maybe he could have allowed cross-examination, but he said twice, what do you want to ask?
Yes.
And your client's attorney said nothing.
Well, my client's attorney indicated that after asking twice to cross-examine the probation officer, because
But
at
what
that
would she have asked? The probation officer is not a percipient witness. The probation officer, all she said was, Judge, I've watched the video. I mean, she's just saying, and this is what's happening. And now it's snowing outside. And now he crossed the street. I mean, whatever it is, what difference does it make?
It does make a difference, Your Honor. And what counsel would have asked is, Ms. Probation Officer, you indicated that you have training and experience regarding the identification of firearms. What is your training and experience? Ms. Probation Officer, when is the last time you handled a firearm? Ms. Probation Officer, when is the last time that you examined a firearm for a serial number? Ms. Probation Officer.
But why didn't she or he, I don't know who the counsel was, ask those questions? Why didn't they tell the judge, here are the questions I have to ask? And the judge could have asked the questions. The judge could have allowed, I think the government even said, Judge, allow a little cross-examination. The judge said no. He could have done it. But he could have asked those questions as well.
Could have. However, a judge, as Your Honors are aware, is not the gatekeeper of cross-examination.
Well, he's the gatekeeper of relevance. I mean, you know, if his counsel, Mr. Perez's counsel, said, ask when the probation officer last handled a gun. No, it's irrelevant. What's your next question? He could have done that.
The court could have done that.
And there would be good reason for doing that in this proceeding.
I respectfully, Your Honor, I disagree that there's good reason for doing that in this proceeding. However, before we can even get to that step, Your Honors, the fact is that the district court didn't even do a balancing test to determine if cross-examination was appropriate in this.
Well, it did do the balancing test, the Jordan test, on the police report, it just
Correct.
didn't do it on the video.
Correct, Your Honor. Only as to the police reports, not as to the video and not as to any witness questioning, I'll call it at this point. What I mean, Your Honor, by the fact that the judge is not the gatekeeper of cross-examination, even in a supervised release violation, and the defendant, whose liberty is at stake, and who's the probation officer in her report indicated that she is asking for detention, she is asking for revocation, she is asking for time in custody. What I mean by saying that the court is not the gatekeeper of cross-examination is that cross-examination is to flesh out in part bias, motive, interest. This is an individual that has a probation officer that has quite a bias, motive, and interest because they themselves have asked for Mr. Perez to be revoked and to go into custody. What I mean by the gatekeeper, of course, the court and His Honor is the gatekeeper of relevance. He makes decisions on the bench. However, an individual's cross-examination has never been through another person. If I have questions...
Yeah, I'm with you in front of a jury, but I'm not necessarily with you where the judge is the decision maker. And I think the bigger issue here, to me at least, is not the issue of whether Judge Seeger should have allowed some cross-examination, but what happens when he says to your client's lawyer, what do you want to ask? And there's nothing. So he says, look, I'm just not going to allow this free-for-all here when there's no jury.
Correct.
Now, I'm the decider, so I can decide what topics you want to ask the probation officer about that are relevant to my decision. Then we'd be here on a different question, I think, right? That Judge Seeger should have asked those questions or should have allowed those questions. But we're not, because your client's lawyer said nothing. I have nothing to ask,
And
essentially.
Excuse me for interrupting you. Your
No,
Honor.
it's okay.
And respectfully, the issue is in part, or not even in part, I would say in whole, is we do try and respect as much as we can the court. And once the judge indicated the first time that he would not allow cross-examination, and then a second time counsel asked for cross-examination, and he denied that again. There's a period at that point where, as counsel, you have to make a decision to say, okay, I'm going to move forward for the best interest of my client, whose freedom they are trying to revoke, whose freedom they are trying to take away, and absolutely respect the court's decision to not allow questioning. If counsel, even at, let's say, Your Honor brought up at trial, okay? If counsel at a bench trial, okay, now I know the standard's different. I know this is a supervised release violation. But if counsel at a bench trial has to ask all cross-examination questions, or any cross-examinations, through the judge.
Yeah, I'm with you, but I'm thinking of it more of an offer of proof. You know, where a judge says, look, counsel, I'm not going to let you get into that topic area. And the counsel says, Judge, let me make an offer of proof. If you would, this is what the witness would say, or this is what we believe the witness would say. Then we have something to review.
The judge didn't use the words offer of proof. He didn't ask for an offer of proof. In fact, what he did was say no to counsel twice regarding cross-examination questions. And he did in part rely on the comments, witnesses' statements in making the decision to revoke Mr. Perez's supervised release.
What's the basis for saying that?
I'm sorry, I didn't hear
What
you.
is the basis for saying the judge relied upon what the probation officer told him?
Yes, Your Honor. There is, in the transcript, Your Honor, from the revocation hearing, the judge specifically indicated in regards to the identification of Mr. Perez that he had established on his own that it was Mr. Perez in the video. However, he used the probation officer's statements to corroborate, is the language that he used.
Where do we have that?
Judge, if I could have one moment.
Sure. Please.
I can get you that.
It's critical.
Yes, Your Honor.
I don't have the page number, but I think he said that the probation officer, and I quote, was well familiar with the defendant. She identified the defendant and the person in the videos. and then said that the identification corroborated the court's impression. I don't know if that helps you find the page. I don't have the page number.
That's correct. Sorry, I don't know about the mic. That's correct, Your Honor. And the government's brief even mentions that, and thank you. It's on page 71, Your Honor, of the transcript.
What about the firearm issue?
In what regards?
Well, did the judge rely upon the probation officer's testimony that it was a firearm?
Well, that's an interesting question. The judge did not specifically say he did not, but he did not specifically address it. It is accurate that from the transcript on that page 71 that was just referenced, that the judge did rely on the probation officer's statements for the indication that it was Mr. Perez. The judge was silent on that issue. And so we don't have an answer. And so this court doesn't have an answer to that either. And when we are looking to revoke and take away someone's freedom and place them into custody, an answer is needed. The proper procedure is needed.
Well, there was, because he said what he relied upon. And he just didn't mention the probation officer's testimony. Because he does say, look, I watched the video. Looks like a gun to me. And I think the argument was not so much it wasn't a gun, but it was a fake gun. Or it could have been, I didn't think Mr. Perez's lawyer was arguing it's not a gun. I think what he's arguing is it's not a real gun.
Correct, Your Honor.
And then Judge Seeger said, look, this is what you do with a real gun, not a toy gun. And so he found by preponderance of the evidence, and the question for us is that finding clear error?
That's correct, as to the gun issue. That's correct. However, a judge's silence, we have to then interpret. This court then has to interpret.
Well, that's not really right, because otherwise the judge would have to say everything that the judge relied upon and everything that the judge disregarded. So I relied on this, I didn't rely on this.
We do require judges to do that. We do require judges to say what they rely on. We do require judges to make an entire and complete record. If we think about a sentencing hearing, judges are required by Congress to indicate exactly what they relied on in sentencing somebody. They are required to ask, have I addressed everything in mitigation? I see my time is up, Your Honors.
You may finish up. Yeah.
And therefore, it is not that we should, we do require that. I would like to reserve the rest of my time for rebuttal.
All right, you have used that time. We'll give you a brief amount of time for
Thank you,
rebuttal.
Your Honor.
Thank you. We'll now move to argument on behalf of the appellee by Ms. Morgan.
Good morning, and may it please the court. My name is Alex Morgan, and I represent the United States. The procedures at issue here in the defendant's supervised release hearing complied with Rule 32.1 and the Constitution. The probation officer, a neutral arm of the court, did not need to be subject to cross-examination. Defendant's confrontation rights in this context are limited, and they're limited to confronting adverse witnesses. And there's just simply no meaningful sense in which the probation officer here functioned as an adverse witness.
She's the complaining witness. She initiates the whole proceeding, right?
That's correct, Your Honor. And
she's the one who recommends to the court you need to revoke.
That's correct. That's the probation officer's role as supervising the defendant at the court's direction. And the probation officer is required to file violation reports with the court, as she did here. It's the government's burden, however, to prove up those alleged violations.
And you do that with whom? Typically the probation officer, right?
I think it would depend on the context, but in this particular case, the government did not rely on the probation officer in any way. The probation officer...
Right, you didn't. The question is, did the judge?
I think if you look at the transcript as a whole, it's clear that the judge did not rely upon the probation officer's statements in reaching its factual determinations.
Okay, he says it corroborated his own views.
That's true. So there's two factual issues here. As to the identification issue of the defendant, which is less contested, and I think the record bears that out. But as to the identification of the defendant, It's correct that the judge notes this corroborated my view.
Suppose the judge had said, I am relying on the probation, just had skipped his own view and just said, the probation officer knows this guy well, she watched the videos, she says that's him, I think that's him. What if that's the record?
I think that would be a closer call, certainly.
Definitely. Why wouldn't cross-examination be required under that situation?
I still think we have to look at the fact that the government did not call this individual. So the probation officer filed her violation report, and the report itself states there's video footage of the defendant with a gun. The government then bears the burden to prove that up, and the government does so with video evidence that's wholly independent of anything that the probation officer says at that hearing.
You seem to not want to answer the hypothetical, which is the judge says, I'm relying on what I heard from the probation officer, after having prohibited cross-examination.
You could say yes, that would be a problem.
Yes, I think in that case, that would be problematic in terms of not allowing the cross-examination. And
it sure would. And the problem that I have in this case is with the, I've never, frankly, seen this procedure on such critical points before. And I am very troubled by the idea that we might bless this procedure, subject to a Talmudic parsing of the judge's explanation to decide just how much he or she relied upon statements by the probation officer or somebody else who was not allowed to be cross-examined.
Understood, Your Honor, and this is perhaps a bit atypical procedural-wise, but I think that does not mean that a violation of supervised release would not have been found absent, taking into account the probation officer's testimony.
So you want to argue harmless error here? Mm-hmm.
I think that if there was any error of defendant's limited confrontation rights, yes, it is certainly harmless.
Isn't the better argument here, because that would be a problematic case if the judge relied, the not an adverse witness argument is very tough. Okay, she's testifying, the probation officer is testifying to things that are very adverse to the defendant's interest. She's identifying him in the video. That's damning testimony in this case. But the judge has the ability to control the proceedings and the manner in which the proceedings are done. And when defendant says cross-examination and the judge says on what, and the defendant says, forget it. Isn't the judge within his right at that point to say, no, I'm not just going to let you come up here and have this free-for-all. There's no jury. I want to know on what subject you're going to cross-examine. And when the defendant's counsel says, essentially, I don't have any subjects, or I'm not going to tell you, that's it. There's no constitutional problem at that point. The judge effectively allowed cross-examination.
Yes, and I think the judge also, as I think Your Honor may have pointed out, twice offered defense counsel that opportunity to provide it with questions. And at one point, defense counsel says, I can argue the point without even doing that question.
Because she's just arguing it's not him. We all watched the video. It's not him, and it's not a real gun.
That's correct. And the defense counsel does make a somewhat lengthy argument saying this officer had no, she wasn't there. She didn't recover a gun. She didn't hold a gun. She didn't see this in person. And so the court, as the fact finder, is able to take all of that into account when making its factual findings.
So if the narration had morphed to characterization, and defense counsel spoke up and said, nope, it wasn't the right hand, it was the left hand that this object was in, that's opening a door for possibility of questioning. Even then, though, it seems like we're backing up. The idea was this video is being shown in a courtroom, and there's a court reporter there, and the district judge is saying, well, we've got to describe what's going on. And that's the genesis of where this came from. Is that correct?
That's correct. And that's why I think it's important to look at the record as a whole, because the court says multiple times, I need a warm body to tell me what's going on the screen. I want to make a
I'm
public
not
record.
sure why, by the way. I mean, we could watch the record. We could watch the video.
Fair enough, Your Honor. I don't think that was necessary. But that was the court's preference to get that on the record in that manner. And
I mean,
it shows.
I'm a little troubled by the adverse witness testimony. You know, when I was an assistant U.S. attorney, one of the first things I would do is put the witness on the stand and say, "Can you identify the defendant?" "Yes." "Where is he?" "He's right over there wearing the suit with the black tie." And I think that's actually pretty good testimony for me. And that makes the witness an adverse witness. And I would think the same of the probation officer. Is that the defendant in the video? Yes.
Right.
It's good
and
testimony for the government.
The government certainly could have done that. The government instead presented pretty voluminous video evidence.
Yeah,
in
but
which you could see
what the government
defendant.
did and didn't do, I don't think makes any difference. It's the defendant's interest that the court needs to protect. And whether it's the judge that's asking the question of the probation officer or the prosecutor asking the question, I don't think it makes any difference. The judge could say to the probation officer, "I have certain questions for you that the government doesn't ask. Let me ask you about history and characteristics of the defendant," whatever. The government thinks, "Ooh, I wish he wasn't getting into these things," but he is. At that point, I would think the judge would have to allow cross-examination of the defendant, even if the government said we don't want cross-examination. In other words, the judge can make the witness an adverse witness as well as the government. It doesn't have to be just the government.
I think that's right, but the government does bear the burden here. And I don't think that the probation officer, by submitting a violation report with allegations saying defendant had a gun, automatically becomes an adverse witness. So the question is then, what happened in the proceeding? At what point are we willing to say that made the probation officer into an adverse witness? I
think once she answered the question,
This
it's
is a
him.
lot.
Maybe once the question was asked, it made her an adverse witness.
I worked very closely with many terrific probation officers, relied on their advice about sentencing, and never thought that sentencing advice had to be subject to cross-examination or even necessarily disclosed to the defense or the prosecution. But when you get into a revocation hearing, things seem to me quite different, and I guess I'm not seeing any reason to discourage use of a bright line. If you're providing information in a revocation hearing to be used to revoke liberty, put them on the stand, subject to cross-examination.
That rule, Your Honor, though, I think would make the probation officer into an adverse witness at every single revocation hearing.
What's wrong with that?
Yeah, so what?
And I think that would be fine. I mean, the probation officer here is viewed, I think, under this court's jurisprudence as a neutral information gatherer.
Well, in some situations, that's correct, particularly with respect to sentencing. But when you get into revoking the supervision that is being provided by the probation officer, it's pretty stark.
Same with bond hearings. In a bond hearing, the probation officer may testify to things that the probation officer has learned during his or her investigation that would make her an adverse witness, and they certainly become a compelling witness for the government at that point. In other words, I just think this opinion could be much narrower than what the government is advocating for here.
Yes, and I think that what the government also recognizes in the alternative is that any type of error was harmless here because counsel was given the opportunity to provide questions to the judge and was able to make the arguments about any shortcomings in the probation officer's testimony or statements, however you want to view it, in her argument to the judge. If there are no further questions, the government would request that this court affirm the revocation of defendant's supervised release.
Thank you, Ms. Morgan. We'll now move Ms. Singer to you for 2 minutes of rebuttal. You're welcome.
Thank you. Just very briefly, I just would like to address two issues that were raised during the colloquy with counsel. Your Honor raised whether or not the judge basically effectively allowed cross-examination. And respectfully, he did not effectively allow cross-examination by saying, ask me, what you want to ask, and I'll determine, in essence, if that question is asked. I do respectfully understand your.
Go ahead.
No,
I'll
that's
let-
okay.
No, you go ahead. You go ahead.
I do respectfully understand Your Honor's inquiry and point. However, cross-examination, had counsel asked a question, and if the judge said, you can't get into that area, that's the way that cross-examination happens all the time.
I'm with you if there's a jury. My concern is, and what happens in the district court is a unique thing, right? Because on appeal, we're looking at a different thing. In the district court, right after the judge finds finding that that's a defendant, the judge has to decide how much time is he going to do in jail. And he serves to the same lawyer that just asked those questions on cross-examination and says, what's your recommendation? So I think it damages the lawyer's credibility as a practical matter if the lawyer says, Judge, I'm going to get up and cross-examine the probation officer on the identity of the defendant. When it was, oh my gosh, everybody knows it's the defendant, and makes the argument it's not the defendant, and the judge then finds it is the defendant. Now what? How much time should I give him? So in other words, there's a strategy decision there in what questions you're going to ask. And it may very well have been that Mr. Perez's lawyer made a decision as a strategy matter. I'm not going to ask these questions.
You're not wrong, Your Honor. There's a trial strategy every time we appear before the court. But it is not uncommon for a defense lawyer to zealously advocate for their client during a trial or during a revocation hearing, and then have to zealously advocate for that same client at sentencing.
Yeah, I'm with you, and I just think both sides here are asking for a broad opinion that pronounces these, you always have the right to cross-examination, or you never have the right to cross-examination. I'm just wondering if that's necessary in this case, that's all.
I wouldn't go with always. We normally don't use language like
I
always
know,
or
for
never.
good reason. For good reason.
Never say never.
Never say never.
Judge Sadie one time when I was a lawyer taught me, don't say there's never a case in the history of the United States that held, because I might be able to find one.
We never
So I
say
stopped
never.
using always.
Right. Thank you, Your Honor.
Thank you, Ms. Singer. Thank you, Ms. Morgan. The case will be taken under advisement. That completes our hearings for the day, so we'll be in recess.